On behalf of the Faculty of Law at the Chinese University of Hong Kong and the Transnational Economic Law and Dispute Settlement Group at the Center for Transnational and Comparative Law, I will welcome you to DataFlow to go. Let me begin by also thanking the Asian Institute of International Finance Law at Hong Kong University and Professor Douglas Arner for supporting this event. So we all know that data is one of the world's most valuable resources, and cross-border data flows are now the lifeblood of the modern economy. The increasing use of Internet of Things and the growing amount of data generated are driving substantial opportunities, and data and its flow across borders has already significantly impacted various industrial sectors, trade, banking and finance, telecommunications, media, entertainment, healthcare, etc., just to name a few. Data is also transforming international trade more generally. Now, while a number of jurisdictions, particularly the larger leading countries, the US, EU, Russia, China, and a select number of other jurisdictions, Singapore among them, have quite firmly established policies and frameworks regulating data flows and cross-border flow of data, most jurisdictions are struggling really to comply with those differing regimes, and doing so without any comprehensive, holistic framework. This webinar is part of a larger project funded by the Policy and Innovation Coordination Office, PICO, in Hong Kong, where I explore whether Hong Kong should adopt a holistic and comprehensive policy on cross-border data flows, and if so, what shape it should take. Given Hong Kong's reliance on data in its leading sectors, such as finance and logistics, and Hong Kong's reliance on imported data for its growth of burgeoning AI sector and others, this is an important issue for Hong Kong. It's also a complicated issue, and we will hear from experts today presenting, and it's certainly always welcome to hear from a variety of voices. Now, to be clear, Hong Kong does not come to this issue with a clean slate, nor would any other jurisdiction. We, like others, have piecemeal legislation addressing parts of the issue, and we also have undertaken obligations in free trade agreements, the most notable in this regard being the FTA with Australia, and created what I refer to as a by default policy. The remaining question really is whether such a by default policy is adequate to meet the needs of Hong Kong into the future. And while, of course, I've been referring solely to Hong Kong is not unique in this regard. Most jurisdictions are really in the exact same place. So the applicability of this webinar is really can be extended far beyond these borders. So today's event begins with a keynote address by Mr. Charles Ng, the Associate Director General of Investment Promotion from Invest Hong Kong, and he is going to discuss the importance of cross-border data flows in attracting FDI to Hong Kong. We then move on to a general session where we'll have 3 speakers discussing issues such as privacy, innovation, policy, and the like. And the last section will focus on finance and the finance sector. I will introduce the other speakers in due course, but I'll just briefly introduce Charles at this point. I've given you his title. He's also responsible for establishing and for helping companies establish and grow their business presence in Hong Kong. And finally, of note, he leads the Start Me Up Hong Kong initiative, which aims to promote Hong Kong as one of the world's most vibrant startup ecosystems, which is being held just next week. So I'm incredibly grateful for him to take time out of his busy schedule and be with us today. So I will call Charles, who's here with us live, to come up at this time.
Thank you very much, Professor Mercurio, Professor Arner, and Stephen Wong. Ladies and gentlemen, good afternoon and good evening and good morning to wherever you are from around the world. A very warm welcome to you all to this very important discussion on data exchange and so on. Now, we know, for example, on the first slide I'm going to show you, Hong Kong is a global financial center. It is an international innovation technology hub. as well as international cultural hub where the East meets West. It is really the business capital of Asia, where trade finance, where a lot of data crosses border, and there's a real need for that. Now, we see that, for example, I'm just going to move on to next slide. Now, one of the biggest initiative in terms of economic development on this planet Earth is the initiative, what we call the Greater Bay Area, the Guangdong, Hong Kong, Macau area, which basically covers 72 million people. It's a landmass of 56,000 kilometers, and it has a GDP of 1.6 trillion US dollars. Now, fast forward, today, if it was an economy country, it would be equivalent to greater than that of UK, Italy, and so on. So this is very important in terms of where we are. Now, fast forward 10 years from now, the think tanks and all the businesses are looking at this GDP growth to grow to over 4.3 trillion US dollars. So it will be equivalent today, if it was an economy itself, it would be equivalent to the 11th largest economy in the world. And we expect that in 10 years from now to be equivalent to the 5th or 6th largest economy in the world. So that's very, very important. And as we look at the sectors and businesses, we know that there will be a lot of trade flows and businesses across. And which is very interesting is that now the data also, the other very important area is the what we call the Belt and Road Initiative that a country is looking at in terms of developing. Again, there will be a lot of data flows, a lot of exchange going on there because of trade, because of all the important businesses that will be exchanged. Now, when we look at this platform, we see that there is, when people come here from overseas to come to use Hong Kong as a global financial center, they want to penetrate the Asian market or the mainland market. And mainland Chinese companies are using Hong Kong to go global from here. And when I'm just going to take a very quick snapshot because this is a very big topic, and I wanted to give some kind of market observation as to the cross-data, border data needs and opportunities in Hong Kong. Let's start with the financial services sector. Of course, this is a huge topic, but just to give an example in terms of cross-border data, the HKMA completed a pilot program for banks in Hong Kong and the mainland to execute cross-border trade finance transactions. And this is a pilot program that was completed in November last year. And we're going to see that evolution going on with more and more needs for cross-border data in terms of trade finance and so on, as the whole economy gets digitalized. ICT, same thing with 5G, the mobile and telecom service providers collecting, analyzing, and processing and storing data across border to generate customer insights to improve services. That is a huge area as well. We also see in terms of innovation and technology where startups and scale-ups require cross-border data exchange to visualize and centralize their internal operations for external expansion. So this is something that we're going to see more and more for innovation and technology companies. In consumer products, as more e-commerce, cross-border exchange happens, and there's the supply chain companies are looking at analysis cross-border data to gain a holistic view of what the customer behavior are looking at, and they want to forecast the demand of their clients moving forward. In fintech, insurtech and regtech as two examples will require border framework to expand into the various other areas, including the GBA. And of course, in health, we see that hospitals and medical groups are again using cross-border data to gain a complete picture of medical history as people movement. Some people live over across the border and then live here, and vice versa. How do we get this data exchange as well? In terms of the smart city, we have a Hong Kong, Macau and Zhuhai bridge, which is the longest sea bridge in the world, and it's just across from the airport of Hong Kong to connect it to Macau and Zhuhai. Again, when the authorities are looking at the traffic, how do they kind of monitor the traffic? Of course, I'm talking about the post when travel restrictions will be lifted. when the traffic picks up, how do they monitor the level of traffic and wind speed going through on the bridge so that they can monitor and predict and make sure that it's safe for the bridge to operate. This is an example of, again, using smart city. Last but not least, there's tourism as well, online travel shopping, cross-border geolocations, etc. And one thing which is very important, as we all are here at the university, is education. Again, universities are building campuses across the border and having different platforms in other cities in the Greater Bay Area next door. And how do they exchange that data? And as we know, just to conclude, we know that there are several school of thoughts, but some people are very keen to exchanging data and they see there's a need to exchange that data. There's absolute necessity to do that in order to move forward. And of course, other people are very concerned about how this data is protected and the whole data protection issue. So I guess this is why we're here, and we have the experts today that are going to be sharing their thoughts and insight about the way forward. I don't think we're going to be, Professor Arner, Professor Mercurio, going to be resolving the issue right here today, but it's the beginning of the conversation. And I think this is extremely meaningful because every sector in the economy and every organization, whether it's government or private sector, needs to think about the whole cross-border data, not only in the mainland China and across, but also in ASEAN and to other geographic markets as trade continues to flourish and grow amongst countries in the region and around the world. So with that, I will just stop here, and I want to wish you all a very fruitful discussions forward, and we look forward to a number of conclusions coming out of this discussion today and in the future. Thank you very much.
Great, thank you, Charles, for that, and certainly we will not be resolving all of the issues today, so I'm glad that expectation is not there. The format for today's event, obviously it is a webinar, but you will see that we have a couple of locally based speakers with us at the campus in the Faculty of Law at CUHK, and also some who will be joining us online in the Zoom format that we're all now used to. So in the next session, in this section, we will have 3 speakers, 2 of which will be coming to you via Zoom, and 1 of whom will be based here. So we'll be presenting live, as it were. The first speaker is Chester Sung. Chester is a principal consultant at Security Consulting Services and former chairman of the Internet Society of Hong Kong. I think of note, Chester founded one of the first internet service providers in Hong Kong in 1994 and helped develop information security really into a profession. He also lectures on e-commerce laws and cybercrime management at the School of Professional and Continuing Education at the University of Hong Kong, and formerly was a Chief Personal Data Officer, Compliance and Policy Division at the Office of Privacy Commissioner for Personal Data in Hong Kong. The second speaker is Mr. Stephen Wong, a barrister. He will be joining us live, and Mr. Wong has a very long and distinguished career, a former prosecutor, longtime employee of the Department of Justice in Hong Kong, and also the former Privacy Commissioner for Personal Data. I'm assuming that Chester worked for you, Mr. Wong, and while you were the Privacy Commissioner. He also, at various times in his career, had been seconded to the United Nations Human Rights Committee in Geneva and New York City, loaned to the Commerce and Economic Development Bureau of as Director of Economic and Trade Affairs in Brussels, and subsequently head of the Economic and Trade Office in Berlin. He also was appointed as Secretary of the Independent Law Reform Commission of Hong Kong and head of its secretariat. And now, as I mentioned, he is a practicing barrister. Our third speaker, who's in Australia coming to you from Zoom, is Simon Lacy. He's currently a senior lecturer at the University of Adelaide's Institute for International Trade. Formerly, he is Vice President of Trade Facilitation and Market Access at Huawei Technologies in Shenzhen. And prior to that, Simon worked as a trade and development consultant in more than 30 countries, training and advising in areas of trade and investment policy. So I will, at this stage, Chester, I will turn it over to you. Each speaker will speak for about 10 minutes, and then we will save questions for later.
Okay, thank you. My honor to be here. Thanks, Ron, for inviting me, and thank you for CUHK Law faculty to organize this event. Let me try to share my screen. Let's see. Are you able to see my screen now?
Yes, we can see it now, Chester.
Okay, good. Thank you. All right. Since we don't have time, and I want to listen more to Stephen's talk, so I get right into it. Okay. Well. I'm going to talk a little bit about actually some recent cases and also about technologies behind it, why cross-border data flow is important. So first off the press, we had this decision from the Portuguese CBA, the NCD, on the case of the Portuguese National Statistical Institute for its 2021 census exercise. Now, they employed a US-based content delivery network service provider, Cloudflare, for their collection for the websites census2021.ine.bt, which was used to collect the census information and personal data from its citizens. Now, between for those of you who are not so familiar with what CDN is, imagine that you type in a URL, through your computer to access a website. Instead of connecting to the computer directly or to the server directly where the company is, you connect to the infrastructure of the CDN or the servers provided by the CDN, which is usually located in an internet exchange point, either in your city or maybe the country, or even in at least in the continent where you're located, to save speed, to allow you to have faster access, save bandwidth, and also it also provides some kind of security protection against cyber attacks. Now, in this case, the algorithm used by Cloudflare or designed by Cloudflare was designed to choose the closest server located at the state of subject, and in this case, we assume it will be in Portugal, or at least in Europe. Further, but then it also allows Cloudflare to utilize its infrastructure located in more than 100 countries, including the US and many other countries in Asia as well. Now, further in the inquiry, it was found that one of the servers associated with the website, Census 2021, was located in the US. And you further admitted that it has no control or no knowledge of location over the transmission of every citizen's data once is on Cloudflare's network. Now, the other issue, which is also quite disturbing, is that the encryption technology that was used by Cloudflare to protect the data in transmission, we normally use, keys, public key and private keys in this case, to encrypt the data. Now, instead of using its own keys to encrypt the data, it allows Cloudflare to use their keys instead. That means Cloudflare can decrypt the data, passing to INE at any time if they want to. So as a controller of the Census 2021 exercise, INE did not conduct any data protection. It did conduct a data protection impact assessment on the information collection or the census collection part of it, but it did not conduct an assessment on its application system operation. And nor they did consult CMPD on any potential risk of inadequate protection of personal data involved, under the requirement of Gdpr. So, and then of course, based on the CDU decision in terms to judgment, which I believe Stephen will talk a little bit more detail into that. Personal data being transferred to the US could not be guaranteed the same level of protection offered by GDPR. And also INE was held by CMPD that they are still liable on the protection of the data, even the data was transferred to a third country under Article 5.2 of the GDPR to the accountability principle. So at the end, CMPD ordered INE to suspend the transfer, which means suspend the use of the service from Cloudflare within 12 hours of the decision. So that was a very recent case involving cross-border transfer. Now, let me talk a little bit more of what CDN is. Now, so imagine, like, I understand the diagram may be a bit small, through a screen, but you can see, like, when you access a website from your computer, instead of accessing, say, from where you are in Hong Kong to another computer or another server located in Europe, instead of connecting through the continents, you access to the closest ISPs or to a local exchange point where the CDN provider would locate their servers. So instead of, so you get to save all the time, higher speed access, and also the cost of renting high bandwidth connections between, the continents, right? And the service provider also provide a very important layer of security services, which could give the attackers, cyber attacks far away from the core infrastructure of the client. So the CDN provider would, use data analytics to determine in real time when you access a specific server, what is the shortest and quickest routes available when you make the request. Now, let's show you a little bit what the internet looks like in a way. Now, very quickly, this, you're seeing the dots. Now, this is the line. You see all these lines and dots and things. The black lines are actually submarine cables connecting to continents. The brown lines are fiber optics cables connecting different countries. And the green dots with X, they are internet exchange points where submarine cables usually, or major hub connection between countries are connected, right? So this, you see all these lines going into this little X here. This is Hong Kong. So we are actually a very major hub in Asia that helps to connect all the submarine cables and spread it all across to China and also much of the other Southeast Asian countries. It's actually more.
Chester, I don't want to interrupt. Sorry, but you're off the slideshow, so we're only seeing your front slide. We're not actually seeing the map.
Okay. See. Sorry.
So I think the link didn't connect.
No, but I actually, for Zoom, I need to share.
I think you need to open the website and then share the web page, maybe?
No, I need to share a specific app with Zoom. Yes. Okay, sorry about this.
If it's not possible, you can just describe it.
Okay, yeah, let's not spend too much time on this. So in any way, I was trying to show you, the internet is not what we think it is sometimes. It is more physical than we think. I know we are all using our mobile phones to connect, and then our computers often connect to the internet or connect to network via Wi-Fi. But essentially, they are all going back to the cables and fiber optic cables and submarine cables. And a lot of countries in the world are actually not so well connected. They can't afford, or they do not get access to this exchange points where high-speed backbones are landing, as we call it, or are connected. So, which means, in order for them to connect to the internet, they have to cross, the data have to cross their borders to somewhere else. So, and are you able to see my slides now, Doug?
Yes, but in presenter view. So we're seeing your notes.
But yes, we can see the slides.
Let me see. Right.
You just have to launch the show.
Yeah.
Play from the start. Yeah, that'll work.
Okay.
Perfect.
Okay, so in closing, I think, why cross-border data is necessary, why we should, when we design privacy policies why we need to facilitate cross-border data transfer. I mean, we obviously must protect the privacy of people, but then we need to facilitate it. And imagine like the year of 2020 without the internet. I mean, think about it. All of us. I mean, everybody in the world was affected, and many of us, maybe in this room or in this event, had the luxury of connecting to the internet so that we can continue maybe our work in a slightly effective way, but then at least we could still do what we needed to do. Our children couldn't go to school, but at least they could still attend online learning. And much of it, I mean, the world didn't come to a complete stop because of the internet. And so, even medical professionals around the world relied on these cross-border data transfer to be able to share important findings and statistics. ISOC Global, our headquarters, help a city, Alcoy, in Argentina, to build their internet exchange hub back in 2019. And it turned out, with the pandemic, the hub became a critical infrastructure for their hospital, so that their medical professionals could share crucial, updates and research, results on that, right? And so for ISOC, really, we believe the internet is for everyone, and this drives everything we do. Just like and that's why we help developing countries or countries with need to build their internet infrastructure, connectivity, and all that. And as of now, we still have actually only half of the population of the world that are connected to the internet, and then 63%, and that's 1.3 billion kids from age to have that do not have internet access still. So it's a loss of opportunity for the population around the world still have no internet access, and it doesn't apply to only the countries or where the underprivileged or still developing. Even in Hong Kong, we were talking about digital device for quite some time, and of course we made great improvements, but the gap is still there. So why allowing small number of culprits, in the world, and make the rest of us, internet criminals or personal data thieves, right? So that's ends my presentation, and thank you everyone for the time. And sorry about the technical glitches.
That's all right. Thank you, Chester. We will move now straight away to Stephen Wong, who will follow up. And in fact, you mentioned one of the topics of his presentation, which of course is a recent decision of the European Union and how it will affect third countries and jurisdictions. So I will call Mr. Wong up to speak, and we are getting his slides up right now.
Thank you. First of all, let me thank Brian for having me, and also to Charles for remembering me. I used to assist Brian, in promoting the accurate image of Hong Kong, especially in Europe. And that is why Hong Kong has been so successful. I think you would agree, and there is no dispute about this. One of the attributes of Hong Kong's success must be, the rule of law, the legal system, the legal profession. The other one, I think we have been reassured by the state leaders of China, of the mainland China, in fact, our country, to be precise, that the free flow of information is also one of the attributes of the success of Hong Kong. They even went so far to say that it is an irreplaceable attribute of Hong Kong. Probably, I listened to Chester's presentation, and he rightly said the internet is everybody's. The other side of the coin is that personal information is not everybody's. Personal data must be controlled by the person who owns the data subjects. So probably this is the reasons why we have to strike a balance, the right balance, between the free flow of information and data protection. You can see that the topic of my topic today is cross-border stroke boundary data flow. So this is not just a cross-national or transnational issue. It's also an issue between Hong Kong and the mainland of China and Hong Kong, in which cases we cannot say that it's a cross-border issue, to be politically correct, at least. So I'm going to the next slide. Right. To try to protect the personal data of data subjects, individuals, should we say, we have certain common models or legal basis for cross-boundary or cross-border data transfer. Examples include the whitelist. This is, for example, if you satisfy the European Commission in relation to data protection, they will give you a special status known as the adequacy decision. For example, Japan recently got this decision. The other model is certifications, like in APAC with the cross-boundary privacy rules, used to US and EU the privacy shield certifications under the Gdpr of EU as well. And the third model is known as the safeguards model, model contract clauses in the EU, binding corporate rules, and so on. So these are the common models for data transfer. Right. We do have a provision, a specific provision in our laws of Hong Kong, the Data Protection Privacy Ordinance, but not yet in force. In this section, in this particular provision, we have outlined certain requirements for transfer out of Hong Kong, not into Hong Kong, transfer out of Hong Kong. You can find the whitelist is the same as one of the models in country-based. Adequate data protection regime, so certification is another one, consent is the usual one, and the last one, due diligence, safeguards taken, for example, model contract clauses. I apologize for the typo in the penultimate bullet point. It's not use of date, but use of data exempted from the data protection principles. So we have, despite the fact that we don't have Section 33 in force, that is in relation to transfer of data out of Hong Kong, we still have existing provisions, protections, protecting data of individuals. For example, we have certain data protection principles, DPPs, no retention longer than is necessary, no transfer of new purposes without consent, and data security for transferees, etc. And we also have a special clause, provisions about the liability of agents and service providers, overseas providers included. The common practice without Section 33 in force in Hong Kong, we could say the majority of the practices focus on the inclusion of contractual restrictions on transfer. In other words, the model transfer, model contract clauses. And we do provide specimen clauses, guidance. If you go to the website of the Privacy Commissioner's Office, and the address is simply type PCPD, and you'll find the guidance there. Chester kindly mentioned and very helpfully mentioned the Portuguese PDA's decisions after, I presume, after this case of REMS 2. By the way, very briefly, an Austrian applied to the Irish commissioner to stop the Facebook from transferring his personal data from from Austria to the United States. And the first case held or determined by the European Court of Justice was in 2015, striking down the then safe harbor agreement between US and the EU. So that was case what known as Schrems 1. Last year, the European Court of Justice heard the case again, and this is known as the Schrems 2 judgment. And in this case, the court made two very significant decisions or rulings. First, the court struck down the EU-US Privacy Shield Agreement, and that was the successor of the previous safe harbor agreement between US and EU. And the other decision, a very significant decision, was that the court upheld the EU's standard contractual clauses, the SCC, which contain contractual obligations on the data exporter and the importer. The exporter meaning the EU, and the importer for those outside the EU, in this case, the US, and the rights of the individuals whose personal data is transferred between EU and non-EU countries under the Gdpr. The restrictions focus on the obligations on the importers and the exporters, the parties. The parties to the standard contract clauses must verification, that is the first one. Okay, and on a case-by-case basis, whether the law of the data importer ensure adequate protection for personal data as required by the EU law, the GDPR. Okay, and the data protection authority, for example, the case mentioned by Chester, the Portuguese DPA, will have to assess, we have to determine if they are of the view that there's no adequate protection, they will suspend or prohibit the transfer. I'm sorry about this device, not very responsive, right? Okay. So the impact on Hong Kong not being an EU country, and we say we can view the significant impact of Schrems 2 from the point of view of transfer of data from the EU first. If the EU exporter has provided appropriate safeguards, such as the standard contract clauses adopted by the EC, and if the EU data subjects have enforceable rights and effective remedies. Okay, bear in mind that the power of the national security agencies of the US being considered, and the functions of this agency being considered in the Schrems II case. And now these are the criteria that you have to put in your mind or consider when you're making the assessment, when the exporter is making an assessment. The threshold, though, is not too high. The EU data subjects must be afforded to a level of protection essentially the same as that of the EU. Okay, so this is the exporter's assessment. Consider one, the contractual clauses, and two, as regards any access by the public authorities, the relevant aspects of the legal system of the importer. If there is access by public authorities, like in the case of Schrems, the US National Security Agency, they have the power to access the personal data of the data subjects. Then the European Court suggests that the assessment should be very careful. And there is also an obligation on the exporter and the importer. If the importer is Hong Kong, and then Hong Kong will be involved to verify prior to any transfer whether the level of protection is respected in the importer's jurisdictions, for example, Hong Kong's jurisdiction, considering the human rights record, data protection, national security, and surveillance laws. Now, this is a transfer of data or flow of data from EU. What about other regions? I suspect they will be more or less the same because the EU GDPR has caused some sort of a tsunami effect on data protection around the world, including the mainland of China. They have recently presented the second draft of the Personal Information Protection Law, a nationwide protection law, and also the relevant data security law, the cybersecurity law, and so on. And they more or less appear to have focused on the model of GDPR as well, if not more severe in some of the areas, in my view. The transfer from other countries, other regions will be more or less the same, especially from Japan and very likely from Korea as well. Because of the issue made by the European Court on assessment and verification, that is access by public authorities of Hong Kong to the data transfer to Hong Kong from EU. And we note that the recently enacted and implemented National Security Law, NSL, Article 43, and likewise in the implementation rules, the CE, instead of the court, will have the power in respect of interception of communications and conducting covert surveillance on a person suspected of being involved in a national security offense. So the CE will have the power to authorize the interception. And this is, I believe, a similar issue in the case of Schrems II, when you talk about the national security agencies of the United States. The police may require service providers to provide identification records and decryption assistance. So the police will have the power to require such service. The NSL offenses are separate from, and by the way, in addition to existing money laundering and terrorist financing activities. So some tips for cross-border or cross-boundary data transfer. One, review your organization's review existing data transfer strategy, conduct regular audit and inspection, be transparent about it, keep an inventory of personal data, and adopt multiple measures to give more protection, check the whitelist when it is involved. Most important of all, control unintended or unnecessary cross-border and cross-boundary transfer of data. So in order to comply with the national security law and TREMS 2, I would suggest that the organizations should recognize that they, including the management, may be exposed to criminal liability under the NSL, National Security Law. And they better review the business processes and accountability framework, pecuniary or other financial assistance or property will not be regarded as acts or activities endangering national security, and build internal compliance system with very clearly written internal control policies, a national security committee or officer, a reporting system, and a whistleblowing system. Better still, they should adopt the new, in fact, a new set of contract clauses of the EU have been published recently for importing, and don't forget, the onward transfer of data from Hong Kong. So conduct what we call the TREMS 2 assessment and verification when importing the data from Europe, is in particular with the exporters. Okay, and for importing the onward transfer of EU data on an independent, with an independent professional and on their advice too. Hopefully, these advice and professionals, come from Hong Kong as well. That would ties up nicely with our promotion of Hong Kong, being the world information and data center too. Thank you so much.
Great, thank you, Mr. Wong. And I think, your presentation really illustrates the law of unintended consequences as well, and that governments have to be aware really of the effect of one law on other aspects. And so we will, I think because of time, I will just go to the next speaker, Simon Lacy. Simon, are you there?
Yep, still here.
Great. You can say hi to me now, and then you can continue with your presentation.
Okay, let me spotlight myself and share my screen. Okay. Let's see if I can pull this off without any technical hitches. No, that's not it. Sorry. Okay, that's it. Right. Thanks, first of all, for the invitation to speak, and thanks to everyone for showing up and listening to us all today. I saw 85 participants at the last count. That's very impressive. Let me also begin by expressing my sincerest apologies if I've violated anyone's branding guidelines by including the 3 logos of the organising institutions on my first slide. So I'm really going to focus
Simon,
on
can I cut you off? I think maybe the mic is on your shirt, and it's providing quite a lot of static for us.
Okay, is that better?
I think it will be.
Okay, I might just pin it here. Okay. So I'm really going to focus on how governments regulate the digital economy, particularly in the area of international trade. A big part of which is cross-border data flows, the topic of today's seminar. So, as the moderator pointed out, as Brian pointed out when he introduced me, I was previously at Huawei Technologies, where my first order of business when I joined in 2015 was to articulate the company's views on a whole range of issues that were then, as they are now, being negotiated in the context of binding trade rules between sovereign governments on what they can and cannot do in the area of digital trade. So I've split this presentation into 3 sections. First, I'm going to give some background on why governments intervene in the digital economy. Second, I'm going to briefly explain how this has played out predominantly in the digital trade chapters of international trade agreements. And finally, I'm going to recall some very important guiding best practice principles for governments to be cognizant of, and which they should do their best to adhere to when formulating regulations that will inevitably impact the digital economy. So I think it helps to recall and articulate the many reasons governments have for intervening in the digital economy, including any policy rationales they may have for placing curbs or conditions on cross-border data flows. So for those of you who can remember back to the early days of the commercial internet, starting in the second half of the 1990s, governments of almost all ideological bents were very loath to intervene in the internet economy, with the Clinton-Gore administration at the forefront of keeping governments out of internet regulation as much as possible, advocating light touch regulatory approaches. Of course, that has changed, and now with the internet economy simply just becoming the economy, governments long ago recognized that they had to do something, and that in fact the internet economy represented a great opportunity to fast track a whole range of other desirable policy outcomes like fostering innovation, attracting investment, increasing participation in the formal economy, and many others. And more recently, the regulatory battle lines have solidified around the need to correct a systemic set of imbalances that the internet economy, through various characteristics such as network effects, among others, seems to have amplified, such as information and power asymmetries, winner-take-all dynamics, and the ability for technology companies to engage in base erosion and profit shifting to a degree never actually seen in the old days of the purely analog economy. Starting or looking at identifying trade agreement topologies, and starting with the US FTA with Jordan in the year 2000 and culminating most recently in agreements such as CPTPP, USMCA, the Digital Economy Agreement between Singapore and Australia, and the Digital Economy Partnership Agreement between Singapore, Chile, and New Zealand. We've seen some attempt, primarily at the initiative of US-based technology companies and their trade associations, to start crafting rules to govern the kinds of intervention governments have been contemplating or actually making with respect to the digital economy. So, for example, we've seen a moratorium on customs duties on electronic downloads that was enacted in 1998 at the WTO and made permanent in a number of FTAs. We've seen commitments not to discriminate between digital and analog products, commitments to adopt legislative frameworks on domestic electronic transactions, and commitments to recognize electronic authentication and e-signatures, as well as various others. Now, from a policy standpoint, the 3 most important commitments for big tech and for any business operating in the digital economy are number 1, commitments not to unnecessarily impede cross-border data flows. That's what we're talking about today. Number 2, commitments not to force companies to store customer data locally as a condition for market access. And number 3, commitments not to require companies to hand over source code or proprietary algorithms as a condition of market access. Now, other important provisions from outside the realm of digital trade chapters in FTAs include 2 provisions typically found in the IP chapters of these agreements, one being an exception allowing for fair use, and the other creating so-called safe harbors that provide protection from liability for copyright infringement by platforms that host and disseminate content. Also, from outside the realm of digital trade chapters, provisions on encryption that essentially prescribe any signatory from requiring providers of encryption or encrypted communications tools from using a local encryption key, forcing them to use a local encryption key, or forcing them to share their own encryption technology as a condition of market access. Those rules can typically be found in obscure annexes to the TBT chapters of these agreements. And finally, many countries are increasingly contemplating the imposition of digital service of taxes on digital service providers, and these disciplines are still being negotiated at the OECD in Paris. So finally, I come to some sort of guiding principles that governments would be well advised to remember and adhere to when enacting digital regulations, particularly in the area of the digital economy. So first, we have do no harm, which is pretty straightforward and just intended to give regulators pause before they whip out their proverbial pens and start dictating new rules for businesses to follow. Of course, any new regulatory initiative should be preceded by thorough and rigorous cost-benefits analysis. And even today, it's surprising how many governments, even in advanced industrialized countries, and Australia is a prime example of that, how many governments neglect to perform a cost-benefits analysis before enacting new laws and rules. Number two is the idea of minimal trade restrictiveness, which probably won't mean much to those not familiar with WTO rules in the area of technical barriers to trade. But essentially, this standard means government should enact and enforce regulation in a way that does the least to restrict or disrupt trade, so as to avoid negative externalities like market distortions or to avoid discriminating against foreign suppliers. Interoperability really challenges regulators to think before to think beyond their own narrow silos and to conceive of and implement new rules in a way that allows businesses to comply with them without violating the rules of another regulator or of a foreign jurisdiction. So interoperability can be achieved by using international standards where possible, where they exist, as well as coordinating regulatory action in advance with the business, with the affected business community, as well as with trading partners. Number four is don't be too prescriptive, and here the onus is on governments to tell the business community what regulatory outcomes they're seeking to achieve or avoid, and then let businesses figure out how to do this in the most efficient and cost-effective way. Number five is very much related to the previous few points. Regulators need to think about the compliance burden they're creating and how this will impact the whole digital economy, from multinational corporations to small and medium-sized enterprises to sole traders and entrepreneurs in the startup economy. Finally, and also very much an extension of this last principle, remember that the internet economy is already massively distorted by existing power asymmetries, so that regulators need to be doing everything they can to make business easier for small companies or even sole traders and entrepreneurs. The system fragmentation we're already witnessing plays to the strengths of the big and powerful multinationals who can hire armies of lawyers, analysts, and government relations experts to help them navigate the complex morass of differing rules and requirements. Look at what Amazon has achieved in India, despite the fact that that country is one of the toughest and most protectionist regulatory environments in the world. Apple and Microsoft still have massively important and thriving businesses in China, despite the very different approach to internet governance you see there. And this is because they're big and they can navigate almost any regulatory hurdle. So we need to remember the needs of the little guys when enacting new rules. So that's all from me. Thanks for your attention. I'm happy to respond to questions and perhaps expand more on my experiences at Huawei during question time. Otherwise, here are a number of ways to keep in touch in future. And also, you can follow my work on my website, which I generally keep up to date and which features a broad selection of my writings, teaching, and policy advocacy, simonlacy.net. Thanks again for listening.
Great. Thank you, Simon, for that. And now I know how to contact you. And I think we're going to, at this stage, go straight into the next session. We're a bit behind schedule, so there'll be two speakers in this session, focusing on finance. The first is Professor Douglas Arner, professor at the University of Hong Kong and director of the Asian Institute of International Financial Law. Douglas is one of the world's leading scholarly experts on international financial law regulation and development, and in particular on digital finance, stability, financial inclusion, etc. And the second speaker is Ursula McCormack, who's a partner in cross-border finances and technology for King & Wood Mallesons, and is one of Asia's leading blockchain and financial regulatory lawyers. If you look at her practice areas, you will see she is well-versed and expert to cover these areas with us today: blockchain-based virtual assets, payment technologies, financial service licensing, digital platforms. All of these involve, of course, the cross-border of data flows. I'm going to introduce at this stage as well the final commentator, who's Professor Andrew Mitchell, professor at Monash University. Andrew's a member of the indicative list of panelists to hear WTO disputes nominated by Australia, and has taught and published in a number of jurisdictions, and again is one of the world's experts on the intersection of trade and data flows. So Professor Arner, I will turn it to you.
Thanks a lot, Brian, and thanks for putting this all together. I think we've had a great result, and thanks to Chester, Stephen, and Simon for really, I think, some fantastic analysis and setting the stage. What I'm going to do is I'm going to talk a little bit about the specific context of finance. Let me just bring up a few slides here to help with this. I think when we talk about data regulation and finance, I think makes an interesting case, not least because when we're talking about data flows in and out of Hong Kong, finance is often one of our most significant areas. And I think part of the challenge here, part of the interest, is that if we think about finance compared to many other areas, there are strong rationales why we regulate finance. And those regulatory aspects mean that finance often gets treated differently for a variety of reasons when we are talking about cross-border flows. But at the same time, if we think about finance, finance is one of the most globalized industries, and certain aspects of finance are absolutely amongst our most globalized market segments. At the same time, finance is one of the most digitized industries, and that combination of finances being somewhat different in terms of the policy questions and objectives, the fact that it is often highly globalized, but not always, and the fact that it is most generally highly digitized, brings with it a range of issues and challenges. And I think when we think about the standpoint of digitization, and also when we think about data flows generally, we're often thinking about this from a number of different angles. One way is we have considerations that I'll come to in just a minute around personal data. The second, however, is very much around business data and finance as itself as a form of data flow. So you may be thinking about business information, stock market trading information. You may also be thinking about money and payments, which are in and of themselves data and the flows that you have there. And you also have data flows that come from the standpoint of a variety of regulatory processes. And as a result, in addition to a sort of general regulatory framework around data, you're also looking at issues around flows of finance. And obviously, if you think about the mainland has capital controls. Those are limitations on flows of finance. Those flows of finance are both physical, cash, but also in most cases actually digitized forms of data. That's another. We also have issues around data that is transferred for regulatory purposes. And of course, we have a variety of data regulations which have evolved specifically in the financial services context, often around a range of financial services regulatory objectives, whether those are requirements in the context of how customer data must be kept and stored in terms of account data, or those are information about the core risk data, the operational information about a financial institution, particularly in the context of backups. Or maybe those are data about wider financial stability issues. And so we can think about a range of different data frameworks that will apply when we are thinking about finance and financial services. And to be quite honest, before around 2016, 2017, no one in global finance really thought much about personal data protection law. This is something that, you had all of these financial services frameworks. And I remember really two things coming in globally changing that. The first was actually a series of directives, in particular, MiFID II, Markets in Financial Instruments Directive 2 in the EU, that required digital reporting in a certain way of information relating to EU clients, regardless of where you were doing business from. And this fundamentally changed the way that financial institutions, both in Europe, but also globally, looked at the way that they kept and, of course, reported information about client transactions, particularly in listed securities. The second, which came not long after that, was GDPR, and a realization that in the context of collecting all of this information, there were also new sets of particularly strong extraterritorial requirements around that personal information and the ways that it had to be used. And something that I'll come to in just a second is something that in the context of financial services, a variety of objectives relating to sharing of data have also arisen, particularly discussions around something that is called open banking, which emerges in the context of the second Payment Services Directive in the EU, but is also a formal obligation in the context of the UK and Australia, a policy objective in an increasing range of jurisdictions, and a question that in financial services, looking at how you can enable use of individual client data by other service providers. And I think in addition to many of we're thinking about sort of strategic approaches, we think about these aspects, often they were each coming for individual reasons. MiFID II, post-crisis, GDPR, concerns about digital colonialization, but also very specific cultural concerns about the way that personal data is used. PSD2, a recognition of over-dominance by banks and overcharging in payments markets. But as we begin thinking about all of these pieces, we're starting to see an increasing range of jurisdictions trying to put the pieces together more strategically to think about, from a developmental standpoint, what are the opportunities and how do the pieces work together? An example of that is the EU's digital finance strategy. We're also seeing similar developments in the context of mainland China, which were largely, if you will, propelled forward by a range of issues around Ant Financial, one of China's largest digital finance platforms. So if we're thinking about finance, we're often thinking about base objectives, which are fairly similar: developmental, confidence, inclusion, but monetary stability issues, but it's often really issues around financial stability, and in particular, the role that financial institutions and financial infrastructure may play, where we have large issues around data, market integrity issues, and this brings us in particular to issues that concern money laundering and information sharing about individual, potentially criminal conduct. Market conduct, fairness, and consumer investor protection. This is often around data retention requirements, data storage requirements for data about transactions. Obviously, if we're thinking about financial markets, the heart of much of finance and regulation comes from what's called the efficient markets hypothesis. The core there is data, information, disclosure, and frameworks whereby that information is set in certain forms, it's made available, and it's secured. And we can see issues around this sort of thing in disputes between the US and China about audit papers of Chinese companies. And that's a very specific form of cross-border data access that you begin to see in the context of financial services. And of course, finance has its own framework, which often operates outside of our traditional sort of hard law structure, which is much more around a body of soft law cooperative mechanisms. And I think when we think about all of these pieces, piece that I want, is we're seeing some interesting trends. From the standpoint of global finance, you need definitely access to flows of business data, data about market activities. From the standpoint of customer information, many of the issues around customer information, individual data, are largely similar across financial services and other areas, with the exception of some of the potential additional issues around consumer protection. The different area where we're seeing lots of changes in terms of localization in the financial services context is really about core financial institution risk data. And it's interesting because we're seeing an increasing set of localization requirements in jurisdiction around the world, while at the same time we have separate processes which deal with risk data aggregation. In other words, bringing together all data about an institution's risk profile on a global basis. And so I think the key issues that I kind of want to highlight today are first, that finance is in a pretty unique position when we are talking about data flows as a result of its largely global nature, as a result of its digitized nature, as a result of the fact that it has evolved its own set of regulatory objectives and issues which increasingly interact with data and are being reflected in not only issues around personal data, but also issues around localization of business data. From the standpoint of Hong Kong, I think probably the key approach is to realize that just its own domestic approach really is not sufficient in this sort of global environment, that Hong Kong has to consider its position within the context of the overall country, as well as more global markets, and how it can build a strategy which takes the various pieces of use of data in financial services and tries to build upon its potentially unique access to the mainland without losing access to its other major markets. Thanks.
Great, thank you, Professor Arner, for that. And I think that conclusion certainly gels with my line of thinking, not only in the finance sector, but across really all sectors as it relates to the cross-border and cross-boundary flow of data. We'll move now to the next speaker, Ursula McCormack. Ms. McCormack?
Thank you very much. Now, I will not have slides for you today, and what I want to talk to you is practically my experience advising on the legal and regulatory side of cross-border data transfers for the financial services sector, which is my focus. And I want to talk to you about some of the practical ways in which we think about these issues and really what happens on the ground when we have large movements of data or people wanting to move data. And typically, what I see is clients who want to move data, who want to potentially sell data, who have to move data even when they don't want to, or indeed cannot move data because of a regulatory or other restriction. And historically, privacy, cross-border data controls were really a minor consideration. They were probably a footnote on a compliance policy or in a privacy policy or in a website. But really, we've seen a huge transformation in relation to how we perceive data and how financial institutions are seeing themselves as not only custodians of money, but also custodians of data. And the same is true of large technology platforms as well. And so the discussions we have these days with clients are on things like privacy by design, on data analytics, on encryption technologies, and on things like data governance. And these questions come up a lot because of not only the incredibly rich data sets that we now have, but also the increasingly complex regulatory obligations that follow. And the sorts of things that drive my clients to share data cross-border are things like operational need, including things like cost reduction and deploying service providers in other jurisdictions that offer services at a lower cost. It can be for opportunity, pursuing clients cross-border, deploying new services to take advantage of new linkages like Wealth Management Connect, which very fundamentally relies on cross-boundary data transfers. But also regulation. So when we think about the sorts of things that financial institutions need to do, one of the key things that follows money is data. So when we remit money across the world, it's a series of payment messages that travels through the correspondent banking network, or indeed through other mechanisms to comply with what's known as the travel rule that requires very specific information to follow that money. It could also be regulation because they need to respond to legal requests, and that can become incredibly thorny where there's a conflict of legal obligations. But by and large, I also see a lot of accidental cross-border data sharing, or really just from lack of knowledge. And that can be very much true of the sort of emerging technologies and blockchain segments that haven't necessarily intended to share data cross-border, but indeed have. And there are a lot of barriers to cross-border transfers, but they certainly aren't technical. We can move data so easily that it isn't a question of how, but really what are those controls or those pause buttons that make financial institutions consider how they do it. And yes, Section 33 is not yet enforced, but for financial institutions, they're not just subject to the statutory requirements under Hong Kong law, but they're also subject to the expectations of the regulators. And there have been statements by Hong Kong regulators that really encourage and support compliance with the spirit, if not the letter, of Section 33. And so we do see financial institutions comply with one of the mechanisms to share data cross-border, and also have to comply with a number of other specific requirements. And what's really emerged over the last couple of years is around data storage relating to client records and other business records. And probably one of the best examples of that is the EDSP regime that was implemented by the SFC, which was really intended to help financial institutions utilize new technologies and cloud-based solutions for their data storage, but really needed to grapple with a statutory requirement for the SFC to approve premises, which put the onus on the SFC to effectively govern and impose standards on those requirements. But there can also be other limitations buried in statute. So the MPF ordinance, for example, has a very severe restriction on data sharing generally, and that would extend to cross-border data transfers as well. So we're always looking for those issues that financial institutions need to overcome. And indeed, many are subject to other obligations as well. And we touched on GDPR tonight, and that's certainly probably one of the strongest levels of regulation around cross-border data transfer. But the question I ask myself is, are these barriers really effective? So, I want to believe that the law and regulation are powerful and effective tools. I want to believe that people consider the DPPs when they're sharing data. But really, mostly, in my experience, it's just a painful process. Most people don't read terms and conditions, so you can bury a statement that sits there in a consent or a notice. Enforcement is still building in the privacy sector, and it's encouraging to see more enforcement. And I guess in that vein, the GDPR is quite a useful mechanism because of this requirement around the need for third countries to have an adequate level of data protection, which was indeed tested and found wanting in the Schrems II case, but also because the levels of enforcement. And that is a very important part of any regulations, that there is indeed enforcement. And that can be very challenging in this arena. The role of regulators is incredibly important. Because what I see in terms of incentivizing behavior, if you talk to a financial institution, there can be no higher threat than the threat of removing their license to operate in a particular jurisdiction. And so that license becomes a very powerful tool to regulating the behavior of financial institutions. But I think on top of that, it's around individual obligations and potentially accountability. And it's certainly a trajectory that financial services regulation is on. But data regulation is still at an early stage. We do have representatives that need to be appointed, or privacy officers or other individuals that help as contact points. In the EDSP regime, we do have certain managers that need to be involved and indeed responsible for the compliance with requests from regulator. So we are seeing some of that individual accountability start, but it is a point that is still at an early stage in this arena. The other thing I wanted to signal is really what's changing in the area of cross-border data transfers. And I think the starting point really is a heightened understanding generally around what expectations are of customers, and customers indeed understanding what is at stake. Individuals, all of us really do understand that data is valuable now, and we are starting to see privacy and trust increasingly being advertised as a service. We're also seeing an expanding understanding of what amounts to personal data. So when we talk about the cross-border movement of data, we've generally today been talking about personal data. So data that relates to a living individual from which it's possible to directly or indirectly identify them. And there are certain cases, that there is no personal data, of course, but also many instances when people don't realize that they're indeed transferring or even handling personal data. And examples like location data or IP addresses can be the sorts of things that in certain circumstances can certainly amount to personal data, but aren't necessarily that well understood. But that growth of our capability with technology also transforms what's possible. If we think about the area that I know and love very well, which is in the blockchain virtual asset side, what started off as a seemingly anonymous string of letters and numbers with a Bitcoin address is really a mere pseudonym that can be very well sort of tracked and traced. And indeed, there's many chain analytics providers that can provide very strong insight into the owner of that address. The next thing really in terms of trend is a heightened understanding and focus on data minimization. And I think seeing data not just as an asset, but also as a liability. And we see more institutions responding well when we ask them, do you really need to move that personal data? Do you even need that personal data in the first place? And we have had this massive focus on transparency, on more data, on getting our KYC controls in place, and this hunger for more and more data to meet regulatory obligations, to build cool projects, but also now we're starting to see a little bit of pullback on that because of the obligations that follow and because of the consequences when things go wrong. We are starting to see a bit of that move to individual accountability, as I mentioned, but we're also seeing competitive considerations now come to the fore as well. So entities that vacuum up data from around the globe are becoming very powerful. And they are indeed starting to be broken up. The penultimate point I'll raise is around AI development and governance, and that has a very important link into data and cross-border data. including in relation to things like the proper selection and governance of data to create proper models. And then finally, something that we can't escape, which is the geopolitical and security considerations around cross-border data movement. And I think that's something that is especially important as we start to see the growth of things like central bank digital currencies that provide insights into transaction behavior and individual behavior, and that might well operate cross-border, as well as broader applications of things like autonomous vehicles. So I'll leave it there today. Good to talk to you.
Great, thank you, Ursula. You know, when I saw your background, the psychedelic background, I didn't think that that your talk would be able to match, but in fact, it exceeded the background. I think you made so many really quite relevant and thought-provoking points there in a short space of time. So I was really pleased to hear that. I have so many questions, but unfortunately, we're already literally over time, and so please everyone bear with us as we have our final commentator to sum up, which is Professor Andrew Mitchell. So we can turn to Andrew right now.
Well, thanks very much, Brian, and I'd like to thank all of the speakers for their terrific presentations. As Brian mentioned, I'm aware that we are over time, so I'll just close with some general and brief observations on regulating data flows. I think that a number of the presentations have indicated that regulating data flows requires different kinds of legal and regulatory intervention at the domestic, regional, international, and transnational level. And there are obviously different legal disciplines, such as data protection law, prudential law, intellectual property law, and human rights law that all can be relevant to regulating data flows and thus applied to achieve different objectives. And similarly, there's a large range of stakeholders that are also involved, such as private companies that are largely responsible for providing and maintaining the infrastructure for data flows and regulating the technology behind digital offerings, governments that are concerned with regulating data flows in the public interest, and obviously the multi-stakeholder internet governance community, which is dealing with different governance issues relating to the internet, including engineering and policy issues. Now, the future of trade in digital services and data entails complex and uncertain policy challenges, and balancing these different regulatory concerns is fundamental to ensure a coherent and sustainable regulatory framework for data flows. Now, being the leading multilateral trade institution, I think the WTO is well placed to undertake several of the required reforms to bring about better balance between promoting the free flow of data while protecting a secure and stable regulatory environment for data and addressing the commercial interests of consumers and businesses. But the WTO can't deal with all pertinent issues related to data transfer or act on its own. And instead, the WTO needs to reframe its policy approach to engage with more relevant international and multi-stakeholder institutions and develop disciplines that address the dimensions of data regulation. And I think I'll close my comments there. Thanks very much.
Okay, thank you for that enjoyable talk, Professor Mitchell. We are over time, and so unfortunately, I don't think we're going to be able to address questions. No, I will just end as Professor Mitchell was mentioning, of course, in trade agreements, and he did speak of the multilateral. But you know, in Hong Kong's approach now, it's interesting because we've mentioned Section 33 so many times, which, in my estimation, really looks more like the EU approach. But in trade agreements, the approach Hong Kong takes in trade agreements, it looks very much like really the American, I'd say Australian approach as well. So lots to be done, even at the intersection between the international level and the local here. I thank everyone for attending. I will thank all of the speakers, those who are in front of me in person especially. It's been a joy to hold a quasi-physical event, the first one I've had in a year and a half or so, as well as the speakers from joining us from abroad, one from Europe and 3 from Australia. And I would also like to thank Douglas Arner, the Hong Kong University and his institute for supporting the event. We couldn't have done it without them. And as well as Ronald Yu and Dini Seko and Bonnie Lung at CUHK Faculty of Law for providing support. So thank you everyone for joining us, and we will have an event on in non-fungible tokens, so NFTs, on June 15th. So do look out for that advertisement and join us then. Thanks a lot and good evening.